We will pause right. Okay, so we're back now. For those who are watching our recording, representative capacity, paragraph 19. If one or more of the parties is signing the agreement in a representative capacity and not for himself or herself as an individual, then that party needs to complete what is called the RCSD, representative capacity disclosure. This is a disclosure in which, and I'm going to highlight here on the screen, the party acting as the representative in their representative capacity is representing that the entity for which they are acting exists already. So when your guy comes to you and says, I'm putting together an LLC and we're gonna buy it. Well, guess what? You can't put that LLC as a purchaser until it actually exists. And that state, by signing the RCSD, they're saying that it exists, it's recorded, it's a completed legal action to create the entity. Within 3 days after acceptance, the evidence of authority to act in that capacity needs to be provided to our escrow officer. So it's a very short paragraph, and I need to go to the document. Oh, I thought I had it pulled up. Do you see RCSD on there, guys? I'll search for it. RCSD package, yes. So those who are in class, let's see if they can see this. I wonder if they can see this on the screen. Is there a way to tell? Owen. Oh. Is there a way to tell if they can see the screen? Will one of you guys unmute and let me know that you can see this? Shoot. Can they even hear me?
I could see it.
You can say, okay, there we go. I unshared it, now I'm going to reshare it. Okay, so this is a pet peeve of mine, and so we have, and if you need this in your documents folder, email me. It's kwccbroker@gmail.com. Email me and say, Scott, can you send in the RCSD packet? This is great to have near your desk or wherever you keep important documents, dealing with contract issues, because it's going to tell you how to correctly fill in when an entity or power of attorney, which comes up, right? One of you guys back there had power of attorney not too long ago. So this is how it needs to be, with the caveat that zip form will not allow you to do this correctly. So there's 400-something thousand realtors in the state of California, and not a one of them is doing it right without some sort of workaround. Now, I'm working on that, but there's only so much I can do. But I want you to understand how to correctly do it, because we had an instance where it was dealing with a trust. One of the agents came to me and said that we have to submit all of these contract documents to the trust attorney, the family's attorney, before they'll allow us to put it on the market. The attorney wants to review all the documents. So we had to figure out how to monkey with zip form to make that document look correct and have everything drafted in this way. Now, I figured out how to do it. We used DocuSign, and I almost had to get out the old IBM Selectric typewriter and make it happen that way, because zip forms is so obtuse when it comes to dealing with this. And it deals mostly with the entity at the top line and then the signer down below. When we're talking about the RCSD and the representative capacity, we're talking about an entity that can purchase real estate. However, an entity can't sign. So they have representatives that sign. So if it's a corporation buying real estate, then the president, secretary, treasurer, whatever the corporate documents say that person can do, they can sign. So for my little corporation, if I had enough money to be able to buy real estate, I'd be able to sign, and my secretary, treasurer, vice president would be able to sign as well, because that's what's written into my corporate charter. Same thing with an LLC. Same thing with a trust. There will be instructions in that trust that deal with the distribution or acquisition of real estate. And so this is how we write it. So the top line, the overall name of the trust is the Kate Graham Trust, and big thank you to Kate Graham for putting this together. This is awesome. I have referred to this over the years so many times. It's so helpful. The Kate Graham Trust for the Benefit and Support of Little Old Ladies, dated 1/24/2001. Kate Graham, trustee. That is her signature, including trustee, because she's signing in her role as trustee. Or TE would work. I've seen TT work as well, but that's all essentially saying the same thing. So her signature, when she's in her representative capacity for the trust for the benefit and support of little old ladies, is Kate Graham, trustee. It's not just Kate Graham, because she's signing in her role as trustee. So when you're loading that into DocuSign or whatever, that's what you're going to drop in there. Is underneath it says Kate Graham, trustee, and then the signature needs to be set up that same way. Okay, and then the date. Any questions on that? How about the workaround? Let's talk about it. We'll talk about it every time we go. So if you try to put the Kate Graham Trust for the Benefit and Support of Little Old Ladies, dated 1/24/01, into the purchase agreement, that's going to show up down below where she's supposed to sign on page 9, I think is where the buyer signs on an RPA. That's not going to work because only Kate Graham, trustee can sign. So the workaround is to put Kate Graham, trustee, and then when you're in DocuSign, drop a text box on the original purchase line and fill in the Kate Graham Trust for the benefit and support of little old ladies. That make sense? Nope. I wish there was. I wish that there was an entity contract, but there's not. And I called Zip Forms, and they told me to use the workaround. They're like, well, just use DocuSign to work around. Really? So I called Car Legal, and they're like, yeah, just use DocuSign to do a workaround. Really? I'm paying, I don't know how many, we pay $200 and something thousand a year to the California Association of Realtors from this office alone. And you can't figure out how to rewrite the software so that I can override this as the broker of the whole blankety blank organization. I can't override it so that we can do this correctly. So I can present this to an attorney without 4 hours worth of work. It's insane to me. Anyway, I digress. Okay. Same thing with corporations. So corporation, LLC, and partnerships are business entities. They're going to need a copy of the corporate resolution, the LLC, what do they call it? Charter, I think they call it. There's a document somewhere. There's either going to be a summary document at the beginning that says, these are the rules and instances that apply for these specific things, or you got to supply the whole thing to escrow. As the agent, you don't necessarily need to see that. You don't have to have it in hand, the list of property, but it is a good idea. We've had a number of instances over the last couple of years, especially with trusts, where there's one or two trustees and one trustee signs and the other trustee doesn't know about it, and then they go off and sell it as well. So I got a brother and sister, they're both co-trustees, and they're not talking to each other. The brother has a realtor at Keller Williams Realty Central Coast. He says, go list my property for me. I can sign as a trustee. We list it, we get an offer, we open escrow. The sister also goes and finds a listing agent that she knows and likes. Not with Keller Williams. How fun would that be if she also picked Keller Williams Central Coast? But she listed with somebody else, and they also got an offer, and they also went and opened escrow. It's the property. The property is located in LA, and you would be amazed at how often that happens. I am flabbergasted at how often that happens. Agents, I mean, when's the last time you listed a property? Who listed a property within the last month? Did you check the MLS first? Good. I did too. Not everybody checks the MLS. They're just so zippity-doo-dah-day about getting a listing. They just go in and put it in. They don't check. Sometimes, and this particular property happened to be in LA, so there's different little fiefdoms. So if the property is located in Santa Barbara, you could list it in CRMLS and Santa Maria MLS and Lompoc MLS, and then the sibling could list it in Santa Barbara MLS, and you wouldn't see each other. It did just happen here. So it's a big pain in the hoo-ha. Well, it's going to court. The judge is going to have to decide. It's best, yeah. In that case, they're co-trustees because they were successor trustees. They're co-trustees, and so they should have both have had to sign both listing agreements. Well, yeah. When they showed up to open escrow, when the seller came in and signed their initial documents, the escrow officer should have said, "Okay, I need to see the trust," and then they would have been able to do that. But they'll still keep marching on through escrow, waiting for the seller to come in, saying, "Hey, we can't close until we get that trust. We can't close. We can't close." And then one of the escrow officers in this particular instance, either whether it was the sister or the brother, the co-trustee, one of them saw the trust finally and said, "Oh, well, there's another party. Where are they at? What's going on?" They reached out to him and said, "Oh, we're in escrow. Call my escrow officer." So then the escrow officers talked, and then they talked to the brokers, and the brokers were like, "Oh, shit, here we go." And the attorneys got in on it. So now it's just come to a screeching halt. Well, once there's a full statewide MLS and there aren't any of these little fiefdom bullshittery going on, that is going to be a happy day for all of us, because then we can actually do a check. But there's no way to genuinely check if it is or it isn't on the market. Ideally, yeah, we should, but I can't tell you. I mean, I've listed property without, like, "Oh, my mom has the trust up in San Jose." Okay, let's get it on the market. Let's get offers going. We'll need it to close escrow. But I don't know, probably. And then the sheriff shows up when you're at the doorstep trying to figure things out. That was a fun story. But yes, correct. You should get a copy of the trust, but do you know how to read a trust? Do you know what you're looking for? Well, then in that case, that's a yes. So yes, you would definitely do that. Otherwise, you're going to get in touch with me, and you and I will go through it. Power of attorney, you need a notarized power of attorney, and there are different types of power of attorney. So the power of attorney documents need to state that this person, Kate Graham by Kirsten Klassen, so Kirsten would have specific written ability within the power of attorney document to be able to sign for the distribution or acquisition of real estate on behalf of the incapacitated person. So in this instance, Kate Graham is in a coma or some otherwise incapacitated, and her sister needs to follow through and be able to sell her real estate, whatever. If they have durable power of attorney, then yes, they can sign all documents to distribute the real estate. The question after that is who gets the money, and that's handled by the courts. Most often it's going to go to whoever the property owner is. It'll go into their checking account, and then the power of attorney is limited on what they can do by law. They can't just liquidate, leave them in the dark. Yeah, somebody's out of country, like we get the military wives that'll sign for their husbands that are out of way. There are the final documents. The grant deed will need to be notarized, and they have to go to a base somewhere and sign. So if somebody's some sort of sniper or whatever, and he's off on tour, you're not selling the house till he gets back. Can they sign prior? They could potentially sign durable power of attorney to distribute, to distribute the assets. Yeah, I guess they could. I've never seen it. Most times they won't. No matter how much they trust their spouse, they won't. Right, and Ted's not married. His companion is a companion, so they don't get spousal benefits. So they would have to set up. It would be illegal. It's beyond my pay grade for sure. They'd have to set up power of attorney for him to sign, unless he gets to an embassy and does notary, because the embassy is considered American soil, and so they can do American notary there, which is trusted. Somebody had a hand up. Hand up. Stretching. Okay. Cool. So power of attorney, the interesting with power of attorney, and over the 10 years I've had it come up twice. So you're probably not going to bump into it at all. So this is just academic, but that is the signature, Kate Graham by Kirsten Klassen. So Kirsten is the one who actually is signing it, but she signs her sister's name for whom she is power of attorney. And you write the word by, and then you sign your own signature. Comma POA, yeah, power of attorney, yeah, POA. So that is the signature line. It's a beast if they have to actually go through it and do that. Any questions on that? Like I said, it's pretty rare. If you're dealing with estates and probate, excuse me, you'll need what are called letters testamentary or letters of administration. Those are instructions from the court. This is in the instance where somebody dies with a will or without a will. With a will is testate, intestate is without a will. Not that that matters, but somebody dies intestate, that means the court has to determine what their wishes were based on whatever. I mean, it's really hard. So get a will, people, if you've got anybody. If you have pictures in your wallet, we used to say, and get a will so that they at least know what to do with your stuff when you die. However, this is what it would look like. So it'd be the estate of Kate Graham, case number, blah, 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 blah. It'd be San Luis Obispo, so it'd be SLO, CO, da, 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 da. There'd be a number. And then Kirsten Klassen would be assigned as the executor. And in the case of a female, they call them an executrix. Doesn't have anything to do with anything other than the fact that she's female. Don't get weird on me here. Let's just stay on track. If Kirsten was a guy, it'd be an executor. And she's female, so she's an executrix. That's it. Don't smirk at me back there, Owen. I know you. It's run the same way. That is her thing. So it is run just the same way as it is for a trust or whatever. It is your signature, comma, your role. Cool? And for your benefit, we have a copy of each of these documents filled out correctly for each instance. So the first instance on our first main page that showed the name of the trust and the signing, or how the trustee needs to sign, the first one is a trust, and the first document in our packet is a trust. That's what it looks like when it's filled out correctly. The second document was a corporation, LLC, or I think that's it. This one is Such a Nasty Woman Incorporated. So this is the corporate RCSD. These are the RCSD-S for seller. These would be associated with listing, or yeah, if it's on the listing side, RCSD-B is the same document, but it's represented for the buyer. And that is partially for zip forms convenience, because if you select the B, it will pull the data from your cover sheet for the buyer. If it's listed as RCSD-S, it'll pull the cover sheet information for the seller. Cool? So that's what a corporate one looks like. You'll see Kate Graham, comma, president above, and then down below here where the actual typed section is. Whoops, that didn't do it. Oh, that didn't do it either. It's Kate Graham, comma, president. So next one was estate. Oh, power attorney, excuse me. POA. So this is what the POA would look like. So you can see here that box 1 there, right? So paragraph 1, now we've gone from an entity, trust entity, and now we're in power of attorney land. And so the box for power of attorney is checked, and then the date at which the power of attorney was granted will be filled in there. You'll need court documents to verify that. Kate Graham by Kirsten Klassen, POA. And then the last page of the document is the estate or probate. So when somebody dies, there's 2 ways that the property gets distributed. It's either through the process of probate, and that will have either a will or no will, or instructions or no instructions, because you can do instructions without a will. If you find somebody's journal and they're like, I sure would like to give my son Tom my house, and they forgot to fill out a will, if they find that in the journal and it was signed as a journal entry, then Tom could file with the court, and that could be part of the probate decision. If they have established a trust, family planning and estate planning purposes, the trust is a recorded document, and it is a separate entity. So when one of the trustees of the beneficiary passes, the trustee generally will pass away, the assets are already owned by the trust, and so within the instructions of the trust, so everything just reverts to whoever comes next, successor. So the trust remains the same. It's kind of this big bulletproof dome and prying eyes when somebody passes away. You can't tell what's going on in there. Probate have to give a list of all the assets that were owned by the person. It's public record. You can go down to the courthouse and pull probate records for whoever you want. You got to give them your driver's license, but other than that, you can go look at it. Where trust is separate from that. So if they've got a trust recorded and they die, it's going to go right to the trust, and they could literally sell that property immediately if they wanted to, because the successor explanation is built into the trust. With probate, like our lady who passed away during the middle of an escrow we talked about earlier, her family couldn't follow through with the contract that was established in her name, even if they wanted to, because they were going to use the 401k money from the woman who passed away, and that 401k won't be distributed in time because it relies on the probate process. And anytime you bring a judge and court hearings and other issues up, it's going to take a while. And that's it. I guess this is a blank one. This is the buyer version. So I've got this packet for those of you at home, kwccbroker@gmail.com. Just say, Scott, please send me the RCSD packet. For those of you who are here, save it, store it, scan it, save it to yourself, whatever. This is extremely useful. You now have knowledge that I have had long-term brokers and real estate agents from our community, 20 plus years experience, who don't know how to fill these out. And I learned it from Kate, and I learned it from this right here. So just passing on the knowledge.